Good morning, middle of the week here. Not sure what day you're going to see this, but I wanted to give a big shout out to Tiffany, who brought up a really good question. I know we've touched on this in the past, but to give a direct answer to those specific concerns, this is about a situation where you prevail on your SSI claim, not SSD, SSI. And after years and years, and you have an old onset, so you're really panned out with the proving. Eventually, it just took a long time to get there. And then you see that you're not getting the full SSI amount for all those back benefit months and future months, potentially. I wasn't sure on the question if it included that, but I think it did. So in this situation, if you have a oral verbal agreement from years ago when you couldn't work and sustain yourself, and the person putting the roof over your head, could be a relative, could be a friend, could be somebody, usually it's a relative. And the arrangement doesn't have to be in writing, although that's helpful. But a lot of family do not put lease agreements like this in writing. We're family, right? We're kind of rely on each other, to be honest, right? So if there was an arrangement and it was overt between the two of you that you are responsible for $500-600 a month for the roof over your head, the utilities that's keeping you warm and with water and all that good stuff, and you can't pay it because you're not working and you don't have savings, you can have such an arrangement where it is literally being loaned to you month after month after month. It's called an in-kind loan. They're loaning you the shelter. They're not giving you the money that you then give to them to pay your fair share. So if you had this arrangement, you can go, and if you get your award and realize that they're knocking you down a third for every past month, so you're getting 6 something instead of 943 in this year of 2024, you can refute that, rebut that. I would get potentially even a signed affidavit or something notarized. Doesn't necessarily have to be, though. I just go things that are a little hard. But something in writing where the landlord owner, doesn't matter if it's a family member, and you both attest to the fact that starting back on X dates, you agreed to, you accept the loaning of the shelter, and that one day when you're back on your feet, not necessarily having one SSI, it could be you recovered and could go back to work. It could be you won a lottery. It could be you inherited. It could be you found a treasure trove. Whatever the case may be, when you had the wherewithal, you had an unconditional obligation to pay all these months back. Okay, so when I say unconditional, that specifically means the loan arrangement you guys made in the past, verbally, understood between the two of you, was not contingent on you winning your disability. It has to be where it was unconditional, so that no matter how you come across money, you would have this obligation. Do people breach obligations later? Of course they do. That is not the issue. Whether you would have been good for it later or not. It's, did you have this arrangement, this bona fide arrangement, verbally or otherwise, with your landlord, family member or otherwise? If you did, you can attest to that, put it in writing. Both of you sign that this was the dealio, and submit it. Now, you're probably going to get some resistance. There's a lot of ignoring of these things. So you have to really stay on top of it and keep pushing. If you get a letter where they say, we're giving you the 600 and something, blah, 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 and always read your letters very, very carefully, because you're going to get repeated ones. Sometimes there'll be one that'll be corrected by this one, then it goes back. Like, it's always a hot mess. Read each one. If anyone says you have the right to appeal this within X days, do it if you don't like the result. If it says you're getting the whole 943 because that's what you are owed under the rules, then obviously you wouldn't appeal that. But if there's something else in there that's appealable, you would. So never blow off your deadlines because, well, I'm just going to call them. No, 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 no. An appeal is a legal event that triggers your rights to fight this. Making a phone call and hearing some well-meaning clerk on the other end say, oh, I'll look into it for you. I guarantee you your 60 days is going to fly if that's the limit that they gave you, and you will no longer have appeal rights, at least for that part now. Okay, so if you have the back pay and it is not reflecting the realities of this loan arrangement you had where, one day when you're back on your feet, you're going to pay back that person. Or if you, have an estate somehow, and then you pass, that person would, like any other contract holder, be able to get paid from your estate. Unconditional loan contract, okay? Verbal or otherwise. But you're going to document that it existed back when you started it. Now, let's say that wasn't the case. It really was a gift, and you're not, you understood that, and that is the way it was. It wasn't proper estate planning, but that's how would you know? Now you're at the future, and your continued SSI payments are knocked down to 600 and something because they keep presuming that you're still under this arrangement. If you have since smartly changed your arrangement, and now you're going to get an agreement, and this time, because you should do it, maybe get it in writing. It doesn't have to be notarized, but I happen to like notarizing things. But you can present it now in real time, saying from this day forward, starting, today's July 31st, starting August 1st, this is the arrangement. She owes me $500 a month to cover the, her room and board, blah, blah, blah. Okay. Use that, and then keep on top of it. And again, read every letter, because you're going to get ignored. Most likely, they're not going to do a thing. Sometimes you have to be sending it for 6 months. Combined with phone calls, but never forget your appeal right. So if it ever says you can appeal and you don't, you're going to lose the right. And that back time is probably going to be gone. So get it in. I would mail it, certified return receipt. I would potentially also fax it and keep my fax confirmation. You want proof of what you sent to them, and that you sent it, and that they received it. And that's a certified return receipt. That's that light green card that you fill out along with that little slippy. The post office can help you with that. Just remember, there is a light green postcard that you will be filling out with your address on it, because it's going to come back to you. When that SSA person signs for your package, and they have to sign it to get it, the SSA, then there's a stamp on that little light green postcard, puts it back in the mail, and it comes back to you because you put yourself as the person it gets sent to. And now you have your proof. You've got that SSA stamp or signature, and keep all of that. And that would be proving that they received it. And that's how you're going to fight, so that, say, when they finally have enough staff to deal with your issue of this 640 something or 600 and something, that should be 900 and something since August of 2024, there will be proof that this is when they got it. And of course, it's going to say from August. So if they get it late, it really doesn't matter. You just need proof that they got it, because otherwise things get lost daily. By way of example, I have probably about 3 clients, all different states, who we filed both in application, and I sent in the representation documents, the 1696, all that stuff you do to retain a lawyer or a non-attorney rep. Probably, where are we at? Probably about 5 months ago. And these 3 unrelated cases have not processed yet. One of them hasn't even processed the application, and the other one has processed the application, but they conveniently didn't connect it with the lawyer. I've sent the materials at least 5 times, because after they don't deal with me and handle it within like a 30-day time period, I start sending it again. It's really problematic right now. I'm not sure, aside from going to the congressperson, which I will do, and we've actually kind of got that all kind of lined up for when I'm like, all right, doing it the nice way is not working. I've given them many reminders. I've made phone calls. Yesterday, I was on the phone on hold for about 20 minutes, disconnected. Oh, by the way, this was Reno, Nevada. Come on, guys, you can do better. Call them back again. On hold 20 minutes approximately, and then disconnected again. So, and you listen to the music for 20 minutes, you think you're, oh, I'm almost up there, because they do have a little outgoing message that says, yeah, it's busy times. It just could take 15 minutes of you being on hold. I'm like, okay, I got it on a speaker. I'm going about my business, but disconnected, then you're screwed. We've had venting on this before, but anyway, when it comes to your back benefits for SSI, do everything in writing. Do your due diligence with what I'm telling you, and you can get this fixed if the shoe fits, if your realities in the past and or going forward match what we're talking about today. All right. That is what you're going to want to do. All right. I hope you all have a great day and a great week. I'm in New Bloomfield, Pennsylvania today. I will be back in Stroudsburg on Saturday. I'll see you then. Bye.